also delayed the matter. Okay.
Morning we are.
And congratulations to your institution for holding this excellent uh, program. Shall we start?
Sir, now session is yours, sir. You can, I mean, take for till 4:30, 1
Sure.
5 o'clock.
Yeah.
5 o'clock till 5. Okay. Please, sir, please.
Sharing option is there here?
Yeah, sir, on the top right hand side, after your video and then voice, then you have a arrow mark.
Okay.
Then
But that has been not enabled for me.
Okay, sir.
Organizer has to enable.
Yeah.
It says only meeting organizer.
Yes, sir. Done.
And now
Yes, sir. Done. Yes, sir.
Now it has been made.
It has been done, sir. You share your screen. Screen sharing. Okay.
So I'm skipping few things and going directly to design because these have been covered by some others. So industrial design and geographical indications and plant varieties are three important things I'm going to cover in my presentation today. As you know that India became member of trade-related intellectual property rights agreement of the WTO in 1st January 1995. So India, being a developing country, India got 10 years time to introduce and complete the obligations as per the law, that is international law, the TRIPS agreement of the WTO. So India had to amend its Industrial Design Act, and there were some issues with the old Industrial Design Act. So India amended its Industrial Design Act and introduced a new act in 2000, in the year 2000. And also India was supposed to introduce a law for geographical indications, because before this law came into existence in 2001, and the protection for these geographical indications were given through the Trademark Act. So a sui generis law was required to extend protection for geographical indications. And third and most important thing, that is Plant Varieties Act. The TRIPS agreement gives a flexibility to the member countries. So either member country can extend patent protection, or it can have a sui generis law of its own kind. So India did not follow the international norms. It exercised completely the flexibility given under the TRIPS and introduced of its own kind sui generis law. It's not only the plant variety protection. First time we recognize the rights of farmers. So what is that? How differently we have done? The first country to recognize farmers' rights. So how we have done? So I'm going to tell you briefly. If you look at starting from the industrial design, which we are discussing right now. Yeah, can you see that presentation?
Yes.
Yes, sir.
Yes.
Yeah. So can you see the presentation, industrial design?
Yes, sir.
Yes, sir. So TRIPS section 4 of the TRIPS agreement, provisions give us the minimum standards. What are the requirements for protection of industrial designs? It says the member should provide protection of independently created industrial designs, which should be new and original. So you are aware that intellectual property rights, especially the industrial property rights, some requirements are there getting protection. For example, in patents, for patent protection, it should be there should be novelty, there should be industrial step, and also industrial application. For industrial design, there is a novelty, there is a newness is there. And also it should be original. So new and original, or novelty or the original, two requirements, basic requirements for getting industrial design protection. So this is what clearly written there. That's what we have adopted in our law. So, but again, the international law, the Article 25 of the Section 4 of the TRIPS agreement says that members may provide such protection to industrial design, but it may not extend.
Hello.
Uh, Hello.
Sir, I'm really sorry to interrupt you. If you can just switch to slideshow mode.
No, no, no. I'm not moving the slides not yet. I'm just giving you introduction. Members can decide that designs dictated essentially by technical or functional considerations, no protection can be provided. This is what the Article 25 of the TRIPS says. And then there is a proper examination registry has to be provided. So we have a design registry, and protection. The industrial design owner should have the right to prevent the third parties, without having owner's consent, making or selling or importing these design products. So that also we have incorporated in our law. So members have to provide limited protection to such a period. The term of protection may be 10 years. That is also been recognized under our law. So that is very, very important aspect. So going to our Design Act. So Design Act clearly mentions the definition of design in Section 3D, the Design Act 2000, that design protection, industrial design protection, to provided to the features of the design, forms of the design, and means of the design, and appeal to and judged by the way we feel. So these are the features are included in industrial design. This is totally as per the international standards. So what are the industrial design features under Section 3D of the Design Act 2000 protected is shape of the design, configuration of the design, pattern of the design, the ornamentation of the design, and design consists of is composes of various lines sometimes, or colors also. That is also part of the design which has been applied on a product or an item. So that is also protected. So design has to be whether in a two-dimensional form or three-dimensional form, both are protected. And then whether industrial process adopted for making this design. So I'm talking about the means of production of these industrial designs, either through machine based industrial process, or manually or mechanically or chemically this is produced. 3D printing now happens. Even you sitting in your room, you can do that 3D printing design with minimum equipment, using various chemicals and things. So that can also be protected. So basically, the finished article on which industrial design is applied, so that appeals to eye and also judged by the eye. So that part of thing is also protected. So what is not protected under the industrial design, as per the section 3D of the Design Act, is any mode or design of construction. So the method of construction is not the mode of construction, a principle of construction of that industrial design is not protected. So anything which is substance, a mere mechanical device, it's only a mere mechanical device. So that is not considered as a, and sometimes you prepare a jugaad, normally it helps us to, some device is helping. So such design is not industrial design per se, such device. So trademark is not protected under the Design Act. Property mark is not protected under the design mark. Do you know the difference between the trademark and property mark? I tell you example. Trademark, you are traveling in Indian Airlines, okay, Air India. So Air India logo is a trademark, okay, and you get a booking, you go and sit either in the business class or economy class, and you are served food there. The food, these earlier there used to be steel spoons. Now because of various security reasons, they are not they're taken away, these steel spoons. So those spoons and cutlery used to have uh, the name of Air India embossed on that. It means that is a property of Air India. So if somebody steals it, so and using at his home, when guests go to the home, they know that this guy has stolen the property of Air India cutlery. Similarly, railway station, you see many places the Indian Railways logo is embossed on the chair, on the pillar, on the fan, and inside many materials are there. On that is embossed. That is a property mark. It means this property belongs to Indian Railway, but that property mark cannot be taken equivalent to the trademark. Trademark is is a mark which distinguishes one good from other good. There should not be similarity in that mark, and that must have been explained to you by some other expert while explaining the trademark. Now, industrial design cannot be included for the artistic work under the copyright, but it's a very controversial thing. There is a artistic work copyright, and industrial design there is interface. I'll tell you one or two interesting cases as we move across. So I just want to show this again. So these are all industrial design applied goods which have been made, industrially produced, or maybe handmade or machine made. So industrial design must be new and original. That's what our law says as per the international standards of the TRIPS. And it should not have been published. That's why it should be new. Once it is published, it will lose its novelty. So before publication, it has to be registered first. Otherwise, it loses its novelty, so it cannot be registered. So it should not have been disclosed to the public. So novelty cannot be lost. And it must be distinguishable from known designs, existing designs. So it is in imitation of existing design, there is no novelty again. So if it is a combination of already known designs, again there is no novelty. So it cannot be registered. The basic requirement of novelty test, it has to pass. Similarly, the industrial design should not have any scandalous or obscene matter on the design. So such things, You must have seen that recently some sex toys were given for registration that was rejected too. And there is a big debate over the legal community. So it may be obscene, but there is a design that needs to be protected. In India, such things are not allowed. It may be happening in some other countries. And the owner of the design has the exclusive right. What is the duration? That's what the TRIPS agreement Article 26 talks about. The minimum duration of 10 years protection has to be given. So in India, first duration is 10 years after registration. If re-registration happens, the extension can be done for another 5 years. So technically 15 years protection is given for industrial design. So no copyright if design is registered. So design has to be registered in as a industrial design product under section 2D definition. It satisfies under the Industrial Design Law 2000 in India. So no copyright can be given once it is registered as an industrial design. But if you look at the interesting portion, section 15 of the Copyright Act. So I'm talking about here the famous interface between copyright and design. What is this about? Here, section 15 of the Copyright Act, subsection 1 says the same language which I said about. So if industrial design registered under the Design Act cannot be registered as an artistic work under the Copyright Act. And section 2 of the subsection 2 of the section 15, it says, it gives an exception to that. If it is not registered under the Design Act, that artistic work can be registered here. If that is not registered, it means you forgot to register your design and the Designs Act. Okay, you lost the term protection of 15. You can go and register it as an artistic work under the Copyright Act. Then what is the duration you get artistic work? Life of the author who made the design plus 60 years. Mean after his death he will get 60 years more. Means the mistake you are done for not registering that industrial design under the Industrial Design Act in the industrial registry, you are being rewarded. So that has to be stopped. So that's what the interface creates a problem here, addresses the issue. It says, okay, this has to be done industrially, means some machine process. So it has to go for industrial design. If it is not done industrially, something handmade or handmade design is there, then you come for copyright registration. You will get life of the author plus after his death 60 years. But the moment you get copyright, you start producing that industrially, then that is illegal. You're not supposed to. So if you produce that more than 50 copies, 50 items using the industrial process, you will lose your copyright. So that's what the law now. So this was challenged in Delhi High Court in Samsonite suitcase versus VIP, or famously known as Samsonite versus Vijay Sales also. So Samsonite came out with a briefcase, with a brown briefcase with a blue border. It became very hit in the market. So they forgot to register under that new design under the Industrial Design Act. So they lost the novelty because it was published, it is available in the market. So VIP guys saw the marketability potential of that new product in the market. They copied it. They copied it and started selling in the market. And their outlet Vijay Sales was selling in the market. So Samsonite filed a case on Vijay Sales and VIP suitcase manufacturing company, saying that it's infringement of industrial property. So finally, they failed to show to the court that they have a design registration. because they didn't have the registration. Now they can't go and register under design because they lost the requirement of novelty. Then they started saying in the code saying that we have a copyright registration. Means registration per se is not required because copyright registration is not mandatory, it's only voluntary. So copyright subsists in that. So they have violated our copyright. Then VIP Suitcase Council said, no, we have not neither violated design because design there is no registration, not even registered. Copyright violation happened here because that product has been produced industrially more than 50 times. So automatically it lost its copyright. So VIP copying that and selling, producing that and selling that is not an infringement of intellectual property. Same decision came in Dabur India versus Imami India. Same decision came in the microfiber case. Delhi High Court Justice Mudgal said this. So many people are aggrieved about this provision in Copyright Act. They say that they should be given extension. This is a common law rule. We imported it from the British. It was in this provision was existing in most of the Commonwealth countries like Australia, not only UK, where this origin started, and New Zealand, South Africa, and Canada, everyone has removed this interface between copyright and India still is continuing. The matter is sub judice. Understand one of the I think microfiber case or some other case has been challenged before the Supreme Court. Hopefully, some decision come. But I'm one of the votaries that we should go as per the time. We should strengthen the design law, and a product can have both registrations, whether copyright in the design or industrial design. It should be there because in the market, the investor product has to be, protected. The intellectual property has to be protected. It's good for the creator and businessmen also. Finally, their contribution to the GDP of the country. So, as a consumers, we are not losing anything. That's what I understand. So, I move to the most another important law, that is geographical indication. So you see, given many example, basmati rice. So India got a geographical registration and Pakistan got a geographical registration. Both are fighting in European Union's IPR office, where who will get the geographical industry indication registration for this. And Alfonso mangoes, for example, Agra Peta, whether it is Kolhapuri Chapel or Goa Feni, and Darjeeling tea, the most successful geographical indication registered project, whether it is a Kanchipuram Sari or Nagpur Orange or Bikaner Bhujia. So there are more than 500 products which have been registered. So what is a geographical indication? Why a law is required? How it is different from the other intellectual property rights? If you see the other intellectual property rights, the creator is the owner of intellectual property, whether it is patent or design or copyright or trademark. Here, association of creators or producers are the owners of intellectual property. So before that, we'll discuss what is geographical indication. It's one of the intellectual property rights, intangible property rights. It is an indication, it indicates its origin, indicates its geographical territory or its locality. The Darjeeling tea means tea indicates its location, Darjeeling. Kanchipuram sari means that Kanchi silk sari indicate Kanchipuram. And Mysore sandal soap, Mysore city means Karnataka. Like this. Each and every product, whether It identifies agricultural produce like Alfonso mangoes from the Goa, Konkan, Maharashtra only, and either agriculturally produced or naturally occurring in the that particular area, or manufactured good, Kolhapuri chappal. Those people, the leather workers, they produce that particular area of Kolhapur. That's why it got the Kolhapur, just like Agra Peta. So those are the manufacturer goods, or agriculturally produced goods, or naturally occurring goods in the nature. So these are indicating certain locality, giving some geographical indication. So others cannot take away this and start saying that it is their product. So for that, a registration is required. It cannot be given to one person. There is a group of farmers, a group of artisans, a group of manufacturers indulge in creating these intellectual property products. So these associations of these growers or creators or manufacturers are registered. So community or association of producers registered under Geographical Indication Act, Registration Protect Act 1999, and rules were issued in 2002. Here, now I switch to the third and important thing. Before moving to that, I would like to give you example how Darjeeling tea has been successful, extremely successful in protecting. So all over the world, there have been a lot of piracy of their goods. So with the enactment of this Geographical Indication Act, so protection has been given, and then legally they stop various other tea growers selling their tea in the market as Darjeeling tea. Not only in India, abroad as well. Thus, that was stopped legally. So the last important law which I'm going to talk comprehensively, that is the Protection of Plant Varieties and Farmers' Right Act 2001. So why protection of plant varieties is required? Because breeding of plant activities, so exploitation of new varieties are decisive factors in improving the rural income. So not only the R&D labs of various agriculture universities or multinational seed varieties like Monsanto all indulge, even farmers also indulge in their daily agricultural activities. They do breeding, they come out with the new varieties. So that's what India focused on, the protection of plant varieties. So it is required protection for overall economic development. So process of plant breeding is a long and expensive, it's not an easy task. So provide an effective system of plant variety protection with adequate protection and adequate remedies is very good for the people who are indulged in creation of new varieties, and also for overall economic development. So encourage the development of new varieties of plants is for the benefit of society. And innovation, that's what our intellectual property policy, national intellectual property policy, talk about creative in India and innovative India. So Atal Tinkering Labs have been set up in various schools to help the young brains to come out with their ideas and indulge in this. So at the very tender age, the children are being taught to develop the habit of innovation in India with the new scheme floated by the our Niti Aayog. So international protection of plant varieties. How it is happened, I know it is very important, and what India has done. You know, I should have broken this into two slides, but due to paucity of time, or not. So there is a convention called UPO Convention, Many developed countries are members of this UPO convention. It is, in normal parlance, it is called International Convention of Protection of New Varieties of Plants. So, what is this about? It provides
Presentation is
protection.
not visible.
Uh,
Presentation is not visible.
yeah, because it's not. I'm not sharing this.
Okay, thank you, sir. Thank you.
Is it not being shared? Let me go through. Okay, again. Let me check it. Can you see now?
Yes, sir.
Yes, sir. Now it's
Yes, sir.
visible.
Yes, sir.
Visible.
Yes, sir.
So, what is this UPO convention which India never likes to join? It has a membership of 69 countries. Most of them are Western countries, developed countries, EU countries, America, China, Japan. These are big countries are there because it grants IPR to the breeders of plant varieties. That's why they call it plant breeders' rights. They don't recognize the breeder, Indian farmer. Uh, Maharashtra, the cotton varieties are there, sugar cane varieties are there, maybe bajra variety they may be coming up with new varieties. So a company does a research in the R&D lab, then only it is recognized as a plant breeder. That law, that international law, that's why India has not joined that. It excludes others from the protection, processing, stocking. Once a multinational company gets a plant breeder rights, it excludes the farmer from producing that seed again. So farmer goes to the market, buys the seed, and after harvest, he can't use his own seed for a production again for the next crop. He can't use that processing, he can't stock it, he can't distribute it, market it, sale it, export or import without getting their permission. They say, for so many years, I have intellectual property, you can't touch it. You take license from me, you pay royalty to me. So they get a breeder license. So rights in some countries include harvested material also, because once the plant variety comes, so other harvest material is there. It may be flowers or fruits or foliage. This is also protected. So without the permission, you can't use them for regrowing and all that. And we wanted legal space available to the farmers, concerning that they're also involved in that. So we were watching that UPO convention started in 78. It did not allow farmers. And then 91, it changed its course, but they said only seed produced by farmers for planting back on their own holdings, thereby that can be recognized. They said, we said no, we did not join. So for us a great advantage came by India and negotiating and joining a famous international treaty called International Governmental Commission on Genetic Resources and Food Agriculture. They came out with a new treaty called International Undertaking on Plant Genetic Resources for Food and Agriculture. FAO organization. It is the treaty uh, which they concluded helped India to include the farmers' rights. And moreover, Article 27.3, part 3, subpart B, gives a kind of flexibility to India, that India can have its own law, of its own law, that sui generis law, that helped us to come out with our own law. So that we came out with the Plant Varieties Protection and Farmers' Rights. First time Plant Variety Protection Act, entire world with the name included farmers' rights scheme. So what we gave to farmers? Access to seeds and also benefit sharing and also compensation. So reasonable seed price we have given to them. And farmers recognized as one of the breeder and also reward them contributing to the conservation. So farmer varieties were allowed to register, the registration of farmers varieties. So prior authorization of the farmer essentially to be taken, any commercialization of derived varieties once farmers variety, from that, if any companies, multinational companies trying to do any research. So exemption from registration fee for farmers. Farmers registration, it is free. Whereas multinational companies, they have to pay registration fee. Farmers protection from accidental infringement. Because many farmers, either semi-literate or illiterate. They don't know all this intellectual property and UPO convention, Monsanto company having the rights and licensing and royalties and payment. Poor guys, they don't know. So by mistake, unknowingly, they are using their, products and in other agricultural purposes, that is not infringement. Recently you must have heard that Himachal Pradesh, Pepsi and a couple of companies filed cases on various potato growing farmers there that you are infringing our rights on potato. There we have intellectual property, plant variety breeders right. The finally Indian government said no, go to hell. Even courts said go to hell. And so we balance the rights of the breeders. We do respect their rights, but we also respect the right of the farmer for the access. So that's what the definition of the plant variety we clearly define, that characteristics resulting from genotype of the plant group and how it is distinguished from one group to with at least one characteristic. It has to be different from one variety to other variety, and how it is propagation has to be done. Propagation means the breeding of specimens of a plant or animal by using the natural processes. And if something is unchanged after propagation, so it includes propagating material also, variety. So we have various varieties we recognize, new varieties, extant varieties, transgenic variety, farmers variety, and essential derived varieties. So these kind of varieties. Again here, what are the essentials for registration? There should be a novelty, means there should be new variety should be totally new, and and next, only exception has been given in case of tree survives earlier than 6 years and 4 years before the filing such applications. So these are the exceptions given that, but propagating or harvesting materials should not have been sold before registration. And varieties should be clearly distinct from the existing varieties. And uniformity is there. So variety is said to be uniform. Means, for example, one class of varieties are there. So today it has grown in one manner, and next day it has grown in other manner. Today the new variety is pest resistant, and after one season it has lost its resistance to pests. No, it should not be. So about 10 generations it should be uniform. The characteristic has to be uniform, essential characteristic. It should be sufficiently uniform, it says, and it should be stable. Means these essential characteristic remain unchanged after repeated propagation. That's what I've said. So after season after season, after cropping, so the characteristic which is claimed for registration of a new variety, let us say it is the cotton is a pest resistant naturally occurring. No other this thing pesticide need to be used on the cotton, this new cotton variety. It has to be uniform, it has to be stable, and it has to be distinct, and it has to be novel. These are the essential for registration. So there is a concept of benefit sharing has been introduced. It means that the breeder of a new variety propagation, so he can license it and claim the license fee, and he can share it with the agent or a licensee. A kind of benefit sharing is methodology has been introduced. Breeder means breeder include from farmer. Farmer is also breeder, or a group of farmers is a breeder, or any institution like Indian Rice Institute or ICRISAT, or any other institute doing these things, or any multinational company like Monsanto is also a breeder. So denomination is another important propagating material. So what is the denomination means? The variety, the propagating material means the the characteristics, the genome features of that plant, and essential characters that I've already mentioned. So it also, essential derived varieties. Examples are given here. Genetic engineering happens, deriving a new variety. It may be through the artificial manipulation or recombination of DNA happens. Nucleic acid molecules happen. Mutation. Through mutation, also new variety, gene variety, it may happen. And also tissue culture. Those who are botany students or science students, they know these things very well. So that because I'm a BSc science degree holder, so it's very easy to explain, but it should not be confusing to the non-science students who are listening to my presentation. That's why in a nutshell, I'm trying to explain. The genetic engineering means each cell has an RNA and DNA. So the research and development, these artificial manipulation happens, and they change the varieties using this genetic engineering. Sometimes mutation happens. The mutation has become very common word nowadays. COVID virus mutating from alpha to beta to gamma to delta. Now delta plus variety has come, and even the our vaccines, we have nuclear acid vaccine techniques like RNA based vaccines are there, like Pfizer vaccine, Moderna vaccines are RNA based vaccine. There is no DNA based vaccine. Only India is now very proud to tell world that India has generated a DNA based vaccine by Jairus Cadila, the fourth largest pharmaceutical company in India. What is the beauty of this DNA based vaccine? Unlike other vaccine, you have to take a job, two injections, two vaccines. It is a liquid vaccine, just like polio. You have to take drops, liquid drops, three times with some gaps. That is the disruption, innovation in coming. So DNA vaccine itself, innovation means they are doing away with the injection, the vaccination. Vaccination is done through giving liquid drops. So, innovation is really great thing happening. They also tissue culture, what happened, they use the various parts of the propagating material, they come out with a new variety. And backcross derivative, they call it, and technically, agriculture students must be doing. They're crossing the hybrid with one of his parents. So new hybrid is there is a new variety. You want to come out with one more new variety, उसका बाप से उनको मीन्स दिस पेरेंटल प्लांट से उसको वेराइटी से उसको एक टिश्यू कल्चर कराएगा, म्यूटेट कराएगा वो, और या जेनेटिक इंजीनियरिंग यूज करेगा. So these kind of things will happen. So there are more technology things I'm avoiding, meiosis and all that. These are all things, technical terms. And farmer is defined in the art. Who is the farmer? The person who cultivates the crop by cultivating the land himself, are directly supervising the cultivation or through other person. He conserves and preserves the land and the species and traditional varieties through selection and identification uh, uh, for the useful properties. So that is clearly definition. Is plant variety is also been defined that a traditionally cultivated or a evolved in the field or wild relative of existing variety or so new varieties coming out through that, and farmers variety is exempted from an application and or a registration fee, that is uh, uh, application fee and registration fee is exempted. So you just can apply and get the registration done. And only thing is affidavit has to be filed. So these are the rights. I already told you that farmer will get a right to for the breeding for developing a new variety, and he will get a right on the seed. And there is a seed fund is created by the is brought to him, and he can sow the seeds, can save the seed, can create and sell the seed. So no multinational company say that he has developed a new variety using my seed. So I have the right. So since he has developed a new variety, he can do that. Um, and it is about in detail. I mentioned about the propagating material, his rights over that propagating material, and plant variety registering authority. Either farmer or a group of farmer or organization of make claim compensation in case if a seed is sold to him or any materials are sold to him is not functioning. For example, Monsanto sells him that it is a pest-free cotton seeds, so he will buy it, and pest attack. The name of the pest they mentioned that will never attack, that has attacked and killed it. So he can go for compensation before the authority and get a compensation. These are the rights have been given to him, and uh, it is rights of the communities also been explained. I'm just skipping it. So these are the breeders' rights. Is the right owner have been given exclusive right. They can appoint an agent or a licensee, and if any kind of infringement happens, the civil remedies have been extended to that. And researcher rights have also been recognized under that. Not only the breeders and farmers, and any person involved in the research as per the conducting the experiment or research, coming out with the new varieties with the repeated use of such variety of the parent line. So that can be done, recognized as a researcher variety. So there are various characteristics are there. A very technical thing, I'm skipping this. There is a dust test is done to recognize the variety. It should pass at least one dust test. What is the dust means? Distinctiveness of that variety. Already told you the distinct. It should be distinct. It should be uniform. It should stable. So that test is done on the field. So then only that recognition is given. So already told you exclusion from registration. This fee is not charged from the farmers, only for the breeders and researchers. This even dust test fee is very expensive. About 40 to 50,000 farmers are not given. So what is the duration of protection in case of plant varieties? It is trees and vines 18 years, and other crops it is 15 years. Any extant varieties means already told you, which has been created through the genetic mutation or other lab techniques or tissue culture. they get 15 years protection. So exemptions and infringement, farmers has been exempted. So I already told you he can produce, save, use, resow, exchange. These are the exemptions given to him over others' rights. And if infringement, a person is not a breeder of a registered variety or a registered agent or a licensee, so he is not supposed to sell or export or import those products. So that is going to be an infringement of the plant variety. So plant variety registering authority was set up in 2005. So various registration facilities have been provided, and a national gene fund has been set up. So wherever benefit sharing happens or any compensation has to be given to the farmers as per the existing laws, this takes care of including these benefit sharing issues. So I already told you, a farmer involved in any kind of innocent infringement, so he has been given exemption, including false representation. This is if a person falsely represents a variety, so he is punished with an imprisonment less than 6 months. So false representation is not allowed under this act, and the compulsory license provision is there. So after expiry of 3 years, Section 47 says from the date of issue of certification for that particular variety by the registry, any person interested can make an application for seeking compulsory license, and the authority, after consultation with the central government, if satisfied that giving an opportunity to other variety to produce the seeds, they fix the fee and then give a compulsory license on payment of fee. So that is given. And there is a plant variety protection appellate tribunal. Earlier used to be, now with the tribunal ordinance, recent reform ordinance, all these tribunals have been abolished, whether it is intellectual property appellate board, or which was taking care of the issues pertaining to patent, trademark, design, copyright, and geographical indications, and this separate plant variety protection appellate tribunal also been abolished. Now the commercial courts will take care of these issues pertaining to registration. The commercial court in the High Court, that is the commercial court bench specially created in High Court as per the Commercial Court Act Section 3 and Section 4 Commercial Court Act of 2015. And this is not required. So one important thing, I skipped it while explaining the Industrial Design Act. There are some problems in industrial design. One issue I've already told you. I'm a big votary for that. That is copyright and industrial design interface. The problems which I already explained you that need to be addressed. There are other issues in Industrial Design Act is that the protection of industrial design, whether it is civil remedies or criminal remedies, is not strong. I tell you first, taking the civil remedies. Civil remedies, a kind of a fine of 25,000 rupees is there. That is not suffice, and unless and until strong fine is imposed, and it's not easy for the right owner to stop the piracy, industrial design piracy. That's number one. Number two, many laws in abroad, developed countries, similar to Trademark Act, they have a system of, common law um, test of such uh, protection of these laws. So common law protection is very, very important. Not only the registered designs, so unregistered designs can also be protected. So passing of relief which Trademark Act provides for unregistered trademark, passing of action. Such methodology has not been extended, unfortunately, to the design, which UK Act has, Australian Act has, maybe Canada. So this will help unregistered design, which has novelty, uh, and originality to get registered. So we have to move ahead, uh, and if you want to protect your new upcoming industries, and Make in India, many companies are coming to India and starting their industrial units and producing it. So it's very, very important that Industrial Design Act need to be strengthened. Then we do have civil remedies, they are weak remedies, and we don't have criminal remedies. That is, I think, unfortunate. Many international laws have criminal remedies. Like UK, again, I'm giving you example. UK Design Act has a criminal remedy. India, we don't have a criminal remedy. That should be there. Whenever industrial design law amendment takes place, that should come. And third and last thing I always talk about, the that international application, just like you I know file international application for patent, uh, you don't have international patent application for uh, industrial design. So that is unfortunate. So in patent, we have patent cooperation treaty, uh, and we have the Madrid agreement for trademark, Madrid protocol. So India has extended these facilities. International patent application can be filed under the Patent Cooperation Act. India is a member. Madrid Control Protocol, India signed. So international trademark application can be filed. And industrial design, we don't have, because our Prime Minister Narendra Modi ji is talking about uh, 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 vocal to local, from local to world. So when local products in Atmanirbhar Bharat, these are the slogans he has given. When you are making our local goods famous in the world, so you need to um, have this kind of international protection for us. They can't go on filing application for protection where in every country where his goods are sold, design goods are sold. So in one application, he can get that protection. That is possible when India becomes a member of Hague Agreement for Industrial Design. So that is very, very important. So these are the changes I'm foreseeing for strengthening Design Act. So if you have any questions, you can, I think we have a couple of minutes left. Naxa?
Sir,
Sir, one question from my side,
Yeah.
Dr. Jitin Kumar. Sir, for commercialization of plant variety, there are NBA approval is required or not?
Um, no. It's not a biodiversity authority. You have a different other plant variety authority is there. So that authority protection has to be taken first. So if biodiversity authority will come when you are patenting, patent thing is there, patent issues are involved. You any extract you are taking and you are patenting for that, biodiversity board approval has to be taken. That becomes, this is about, developing of a new variety. So their biodiversity means all existing species. You're using that species, plant variety or a fruit or something, in creating a new medicine. So that traditional knowledge you are taking. So you are patenting that may belong to a particular community. So you need to take NBA approval for that. Then benefit sharing and all that comes. First you have to take access permission, then commercialization, that permissions.
Means that variety is endangered or not, or something like that.
Yeah.
Okay. Thank you.
Next.
Sir, good evening, sir. This is Arun Kumar from Ramco Institute of Technology.
Yeah.
So I'm having a clarification, sir. Recently, I came across a news that, and before that, I'm sorry if you have already answered. I came across a news that PepsiCo have sued Indian farmers for violating the patent
Yeah.
of this FC5 potato variety. So what the farmers have did is that they got a better yield. So they shared the detail with, or the shared the seeds with fellow farmers.
Yeah.
So PepsiCo have sued against that four Indian farmers, and they have
Yes.
claimed around 1 crore from
Uh,
the farmers. So in that way, how a farmer can protect themselves if a corporate is going to sue against them, against
As
their
far the the rights and exceptions which are explained in my presentation. So finally, in this matter, what happened? The PepsiCo has withdrawn all cases. Especially those nine potato growing farmers, and they were seeking 1 crore of compensation damages from each farmer. So it was
yes, sir.
ridiculous.
Yes.
Our law is plant variety. Law is very strong. It's a kind of victory for the farmers groups, and state and center took a clear stand on the plant variety registrations, subject to the farmers' right that they can grow, they can sell, they can reuse, 2 3 times I've said.
Yes.
Even they go and buy a potato variety from a shop, a seed variety for a shop, they take that, started growing. So, and they what they did, just like seed, they have right to seed, again, recrop again. That's what they have done with the
Yes.
potato.
Yes.
So, which Pepsi jokers, their legal team may be weak. They may not be aware about these rules and our law, which is very strong, which has been enacted with the, first objective of protecting our own farmers. Then others will come.
Yeah.
Our act is very balancing. We do recognize their right, but we can't sacrifice farmers' right for recognition of their right. That's what, finally, government of India maintained its strong this thing on that, and law is crystal clear
Yeah.
that farmers' overriding rights will be acceptable, as per the law, and no company, whether it is a Pepsi or Monsanto, can harass farmers like this,
Yeah.
either in Gujarat or Himachal, wherever.
Yeah. Okay. Thank you, sir.
Friends, any more questions? If you have any doubts,
So
please ask.
there is one general query. This is Imran from AMU. I was having some login issue in the second session. Was that conducted or it's a problem from my side only?
No, no, it was conducted. There was no problem. There was some technical glitches at our end, but it was.
No, when I joined, I have seen 13 or 14 attendees, and there were no presentation and there was no screen sharing on my matlab, side. I was able to join, but I found only 13 to 14 attendees. So I thought that there may be some problem, but as you are saying,
For first 10-15 minutes, there was some technical glitch. Then later on, we had both the sessions. Okay, till
is it
1:15 we
possible
had.
that we can listen the recorded session, sir?
Yeah. AICT will will share in maybe on YouTube with you.
Okay, sir. And what is the procedure for the feedback, sir?
You have to check from your own account. There is a feedback option. Okay.
Okay.
You have got your AICT account, right? As a
Okay,
participant.
right.
Yes, yes,
Atal
sir.
account,
Yes, sir.
we have got it on.
You have everything is given there. You can
Yes,
give
right.
your feedback.
Thank you.
Thank you.
Thank you. I got it. Now. Thank you.
Friends, any more? Does anyone has
Sir,
any
So please
question?
provide
sir,
Yeah, please.
attendance sheet.
sir, I want to ask you,
So
sir,
this design
from,
registration, for
sir,
this
for
design
tomorrow,
registration process in brief, sir. What should I do before going for design registration?
For design registration, two requirements I already told you. It should have a novelty. It should not have been published, and the design should be original. Original means it should not been copied from others' work. These are the two things. And then there is an application, online application is there.
Right.
You can design registry, you can log on to IP office. The forms are there. You can make the fee payment online and then apply. That's all.
Okay. Online it can be done, sir.
Yeah.
sir,
Thank you, sir.
So, Professor Nayak.
There is one question. I think Madhur,
yeah,
someone is.
yeah, yes, sir,
Yeah.
yes, sir. It's Madhur Agrawal, sir. I want to know something that for tomorrow's class, as our class will be of 5 days, so for tomorrow's class and next day class, we will get new link or from the same link we
Yeah,
will join.
no. You will get new link for every class. No, today we
Okay.
have 3 class, 3 links we have
Yeah.
sent. But
Yeah.
tomorrow 3 sessions we will be sending separate links.
Okay. Okay, sir.
Okay.
Thank you, sir. Thank you so much, sir.
Okay. Uh, so, Raghavendra sir, thank you very much for giving enough inputs and feed for all of us on design, geographical indication, and the farmers and breeders, right? Because that is one area where most of us are not aware of, because farmers and breeders is a happening thing. As one of the participant was asking about the Coca-Cola case. So, yeah, as you rightly said, their legal team might be very weak in identifying what exactly to be done in this case. So, even I think the potato chips of Lay's also there was some case
Yeah, similar.
in Gujarat.
Yeah.
So, anyway, thank you very much, sir, coming to our platform. We wish to see you in coming days with the similar kind of IP topics.
And my apologies for the delay today.
No, it's okay, sir. It's okay.
All of you, please stay safe and take care and follow COVID protocol. Wear mask. Namaste.
Yes, sir.
Jai Hind.
Surely.
Take care.
Yeah.
Thank you, sir.
Thank
Thank
you,
you.
sir. Thank you so
Thank
much,
you so
sir.
much, sir. Thank you so much, sir.
Namaste, sir. Jai Hind.